I call Claire Curran.
Thank you, Mr Speaker. I'm pleased to take a call on the third reading of the Judicature Modernisation Bill, which has now been divided into 23 bills. This legislation is, I think we all agree, it's very out of date. It's 100 years old, long overdue for an overhaul and for modernisation, and I don't want to cover the ground that's been dealt with by others. I'll confine my comments in my contribution to some concerns that I have about what we've ended up with, and also some pointers really to the way forward if we are really serious about modernisation of the court system, modernisation of our justice system, and some of the work that's being done in that area, which unfortunately this bill didn't go nearly as far as it could have. That being said, there is a lot of important work that's been put into this bill, as no doubt it's been held up in the House. It's a huge piece of legislation. It's been through an extensive select committee process. The main point of concern is around the late deletion of those clauses 167, 401, 544, 565 and 571, which would have required online publishing of all final written judgments. The fact that this was included in the bill as it originally went to the Select Committee was important. It was actually quite radical and really did show that there was steps being made towards true modernisation. Unfortunately, the Minister was spooked during the process of the bill going through the House, and unfortunately also wouldn't support this the supplementary order paper by my colleague Jacinda Ardern in the committee stage, which would have phased this in over time and perhaps addressed those issues around the enormity of the publishing of online decisions and the cost that would involve. Instead, the Minister was guided by the advice that the 15,300 final decisions that would fall within the scope of the requirement of this bill would require around $1 million and 10 FTE publication staff. And I think that was at the point that probably there were words had with the Minister, you know, there's no way that this could be afforded, you'll have to back away from this, and unfortunately it was backed away from. The impact of this is, though, that this therefore is not a true modernisation piece of legislation if we are not moving towards a system where the accessibility of judgments for the public, for people who are doing research in different areas, who don't have access to the legal systems where you can access judgments, if they're not online, if they're not accessible, then we are not truly modernising our system, and we are not making it more accessible to the public and more accessible as a system using the technology that we have available. And I think that's a great shame, and I'm hoping that that we can revisit and redress this at some point in the near future. And I'd also like to remind the government of its obligations under the Open Government Partnership, which it is a signatory for easy digital interaction with government. Access to the justice system and access to the decisions made through the justice system is part of that easy digital interaction with government. And I say that this government should not be paying lip service to these treaties, to these weighty documents that they sign up to that give commitments to being true open government, which is it's a multilateral initiative between dozens of governments and civil society to create a more transparent government regime. So this is one of the things that it could be doing more work in. And it also, as my colleague Jacinda Ardern, runs counter to the very quite strong comments made by the former Minister of Justice, Judith Collins, on this, where we must be able to access it. She said that New Zealanders are paying for this justice, they should be able to access it. So unfortunately that's been wound back on. I also want to touch on, and thinking about the way forward, that there is new thinking in this area, and I would like to hear from the Minister of Justice at some point soon around this, given that we are moving into modernisation of the justice system, that we could be looking at the concept of online courts, an online court system. And there is work being done, Mr. Speaker, at the moment in New Zealand by our only true cyber law expert, former Justice District Court Judge David Harvey, who has just set up the Institute of Cyber Law at Auckland, into the means for more people to get justice faster and cheaper, which is helping, which would help to narrow a civil justice gap and fulfil the state's democratic duty to ensure citizens can have their disputes fairly resolved. This is true modernisation. It's a move looking at how we could move to an online court system where more people can access justice faster and quicker. He points to the fact that currently civil claims make up to $15,000 can be dealt with cheaply in a disputes tribunal, but delays and costs of taking a case to the higher courts are prohibitive for a dispute over less than $75,000. And he also believes that the judiciary is unlikely to propel us towards an online court system. It's a revolution that only politicians can make happen. And there is a considerable amount of work going on at the moment around this. There's been some reports of the Civil Justice Council, chaired by Professor Richard Susskind, about an online dispute resolution for low-value civil claims. A second report has recently been released by an organisation entitled Delivering Justice in an Age of Austerity. And these are processes that are about the resolution of low-value civil disputes up to £25,000. This came from the UK. These are ideas that are really worth thinking about and worth pursuing. And I hope that following on from the Judicature Modernisation legislation, when it passes, that this will be one of the next steps that we can take as a country towards truly accessible justice. I do want to finally, Mr. Speaker, just raise some caution around another part of this bill, which is around moving to an electronic system for the registry courts, which of course is a sensible idea, but where there are precedents, particularly in the Auckland, in the family court, where this was attempted and has been attempted in a few years ago, which has created more problems than it actually solved, serious delays and huge backlogs within the family court by moving to an electronic system. The point here being that whenever these moves are made, they have to be done well, they have to be done properly, and taking NovaPay as an example, where you turn off a system and one system which has been working to bring in a new one, and you don't keep the old system going for a while just in case the new one falls over. This is one of the lessons that we really have to learn within the justice system as well. If we are moving to an electronic system, then we do have to make sure that we're doing it carefully, that we're doing it properly, we're doing our due diligence, and that we don't turn it into another NovaPay.